Now we'll commence our second session titled The Legal Regime of the EEZ under UNCLOS. And now it is time to welcome our panelists for session number 2. This session will be moderated by His Excellency Osman K. Kamara, Judge of the International Tribunal for the Law of the Sea. Judge Kamara, the floor is yours.
Thank you, program host, for the kind words about me. Allow me to express my gratitude to the Ministry of Foreign Affairs of the Republic of Korea and the Secretariat of the ICLS for the excellent hospitality they've accorded to all participants. Distinguished experts, esteemed participants, ladies and gentlemen, I welcome you to this significant discussion on the exclusive executive zone under the United Nations Convention on the Law of the Sea. I'm privileged to moderate this session, a session designed to explore the complexities and emerging issues surrounding the EEZ, a crucial aspect of maritime law. Briefly, the EEZ is a maritime zone where coastal states have sovereign rights over the exploration and use of marine resources, including fishing, energy production, and transportation. As we delve into this topic, let us consider the multifaceted nature of the EEZ, encompassing resource management, environmental protection, and international cooperation. Our esteemed panelists will share insights on the legal regime governing the EEZ, shedding light on its applications and challenges. Throughout this session, I encourage active participation, thought-provoking questions, and insightful discussions. Let us strive to enhance our understanding of the EEZ and its implications for global maritime governance. 4 distinguished experts will lead the discussion, 2 speakers and 2 discussants. Thereafter, I'll open the floor for questions. Because we experienced that during the first panel, we didn't engage our participants. This time around, we intend to give them at least 25 minutes each, so that we'll encourage our participants to also participate. So now, let me start with the speakers now. Our first speaker is Professor Géraldine GIRAUDEAU of the University of Paris-Saclay. Géraldine GIRAUDEAU is a full professor of public international law of the University of Paris-Saclay. She holds a PhD from 2 universities, Paris-Panthéon-Sorbonne and Carlos III University of Madrid. Her research has been mainly focusing on territorial seas, law of the sea, international migration, and international relations. She is currently conducting research on different legal questions specific to the Asian-Pacific region, including impact of climate change on maritime zones and governance of the deep sea. She also served as an assessor judge appointed by the UN High Commission to the National Court of Asylum from 2012 to 2016. She is currently Joint Director for Studies of the French branch of the International Law Association, co-director of the Asian Pacific section for the Annuaire Français de la Relation Internationale, and member of the International Law Association Research Group on Cables and Pipelines. Let me do it this way. I will now give the floor to Professor Géraldine to make her presentation. Thereafter, I'll read the bios of others, and then they also make their presentation accordingly. You have the floor now.
Distinguished guests, annyeonghaseyo. I would like to warmly thank the organizers for this beautiful event and this honorific invitation. I'm really delighted to be here. I've been asked to provide a general presentation on EEZ legal regime, and I have to say that talking about past, present, and future of the EEZ is quite of a program. So I will try today to draw a general panorama and to pinpoint some aspects that hopefully will be the object of further discussions and questions. I'll start with a teasing. EEZ legal regime is not perfect. But is there any legal regime which is so? It's a unique and ambitious normative framework with some limits, which withstood quite fairly the test of time, which is now confronted to important challenges which can be overcome both by political will and evolution, thanks to the flexibility of law, and thanks also to the very important task of the international judges. Let's start with some general considerations. Along with the international seabed area and the common heritage of mankind, the EEZ is indeed the major innovation of the Third Conference of the Law of the Sea. As a maritime zone extended up to 200 nautical miles offshore from the baselines, where a state retains exclusive rights to the exploration and exploitation of natural resources, it is an emblematic symbol of states' growing control on oceans, designed to balance the freedoms of the high seas with the economic interests of the coastal states. It owes much of its origin to the energetic efforts of developing states. Emerging from nothing, the EEZ was adopted within the space of a few years by the vast majority of states. In 1996, 2 years after the entry into force of UNCLOS, 90 states had already created an exclusive economic zone. The EEZ has since become a key institution of the law of the sea. And while UNCLOS and the EEZ was a major innovation in the form of a compromise that made it possible to reconcile contradictory issues and claims, the questions now arises as to whether its legal regime is sufficient to grasp all the current prospects for the development of the law of the sea. And to try to assess this question, I'll first remind how the EEZ became an essential institution of the law of the sea. I'll underline some specificities of its legal regime, and I'll then focus on some current and maybe future challenges. Since the aftermath of the Second World War, the law of the sea had been fraught with uncertainty. The absence of a legal regime for fishing, apart from traditional one of freedom of fishing on the high seas, gave rise to a variety of practices, including the practice of an extended territorial sea up to 200 nautical miles by certain states from South America. These concerns, focused on the exploitation of biological resources, were closely combined with those relating to development to give rise to the concept of a zone for economic purposes under the control of the coastal states, which would avoid at the same time the general extension of territorial seas up to 200 miles. And even before the start of the Third Conference, plans for the creation of a zone to serve economic development were drawn up into different geographical areas, specifically into the Caribbean Sea, and also at the same time, Kenya proposed the creation of an EEZ, a project that was then transmitted and taken through the Organization of African Unity and transmitted to the Seabed Committee. So the second project, as you know, prevailed, and it was debated and commented during the third conference. It was indeed, it arised indeed, sorry, I went a little bit too far, vigorous opposition, especially from the traditional maritime powers. But the determination shown by coastal states and developing states in defense of this notion made it impossible to envisage the project being abandoned. So while continuing to debate certain aspects, the third conference quickly reached a consensus on admitting the institution. And thus, in just a few years, the new EEZ was accepted. the 200 nautical mile zone, which a few years earlier under the heading of an extended territorial sea had seemed exorbitant and unacceptable, was now generally recognized in the form of the EEZ. Over the course of the 1970s, many countries incorporated the institution into their national legislation. Nowadays, as we can obviously observe on a map, waters of the EEZ represent a substantial part of the oceans. Most coastal states, especially former colonial empires, have shown an obvious effort to maximize the effects of UNCLOS, including by creating EEZ around territorial formations whose compatibility with the UNCLOS Article 121 criteria of what an island is appears sometimes unclear. Furthermore, the growing assertion of state rights over the EEZ has contributed in substantially modifying geopolitical relations in recent decades due to the vastness of the maritime areas now under state jurisdiction. This is particularly true for islands, especially for the Pacific island states. We find in this region the vast majority of the biggest EEZ in the world. The 360 degrees projection of islands and archipelagos on the sea implies an exceptional ratio between land area and EEZ, converting small pieces of land into huge maritime nations. The EEZ also easily found its place in the differentiated compartmentalization of zones established by UNCLOS. In general, its relationship with the other zones is one of simplicity, but of course the relationship with the continental shelf is much more difficult, the very existence of the second one having been threatened by the creation, by the project of creating a unique zone. So although the distinction between the two zones has prevailed, it is not without ambiguous implications, particularly in the establishment of state obligation in environmental matters and in maritime delimitation disputes. I won't be too long on the specificities of the legal regime. It's very specific because it is nor the one of the territorial sea, nor the one of high seas, and tries to reach a delicate balance between coastal states' interests and other states' interests. So regarding first the sovereign rights and jurisdiction of the coastal states, the EEZ is a functional zone in which the coastal state only has powers of attribution which are limited in scope and mainly, but not exclusively, economic in character. Article 56 of the Convention, which sets out the general definition, distinguishes between the exercise of sovereign rights and the exercise of jurisdiction in a number of areas. The coastal state has sovereign rights for the purpose of exploring and exploiting, conserving, and managing the natural resources, whether living or non-living, of the waters superjacent to the seabed, as well as with respect to other activities tending to the exploration and exploitation of the area for economic purposes, such as the production of energy from water, currents, and winds. Biological resources were a central concern at the third conference on the law of the sea. They represented the essential and immediate interest of developing countries who wanted to avoid overexploitation of stocks in areas close to their coasts. Even today, the economic aspects are indeed fundamental, since 90% of the fish market comes from EEZ. And despite ever increasing international regulations, fish stocks continue to decline. The consistency of the coastal states' sovereign rights over the living resources of the EEZ is fundamentally based on the right to determine, on one hand, its capacity to exploit the living resources in accordance with Article 62.2 of the Convention, and on the other hand, the admissible volume of catches in accordance with Article 61.1. The terms of Article 62 indicate that the coastal state is bound by the obligation to admit other states to the catch of what remains when it does not itself have the capacity to reach the allowable catch volume. However, the unilateralism implied by the Convention in the management by the coastal states of catches in its EEZ can be counterbalanced by the presence of regional fisheries management organization. Article 56 of the Convention, which sets out the sovereign rights of the coastal states in its EEZ, goes on to set out the areas in which it exercises jurisdiction. This concerns the establishment and use of artificial islands, installations, and structures, marine scientific research, and protection and preservation of the marine environment. Very important challenges for this legal regime nowadays. In recent years, the massive construction of artificial islands off the coasts of certain states has raised important questions about the legal status of these installations and their uses, and obviously the protection and preservation of the marine environment, as set out in Article 56, is the third most important area in which coastal states can exercise jurisdiction, and it is currently maybe one of the more striking challenges. The rights and freedoms enjoyed by third states are the freedoms of navigation and overflight, and the freedom to lay submarine pipelines. And on these 3 points, therefore, the legal regime of the EEZ borrows from that of the high seas. The Convention is elliptical on the obligations of other states in the EEZ. Article 58 quite logically obliges third states to respect the laws and regulations adopted by it in conformity with the provisions of the Convention, and insofar as they are not incompatible with this, with the part mentioned with other rules of international law. So while the Convention does not provide a lot of clarification on the scope of this obligation, the case law developed until now is very enlightening to that regard. So Article 56 could give the impression of an harmonious balance and equitable sharing by obliging the coastal states and third states to take due account of each other's rights and obligations. But we all know in this room that it's been much more challenging than this. And again, that the role of the international judge is absolutely crucial in that matter. At the time of assessing the current and huge challenges of the EEZ legal regime, 2 at least approaches could be retained. So I was mentioning here what we could call the normative approach. It means focusing on limits and absence of certain norms, or the material approach, mentioning some of the events, factors, external evolution, which explain the current challenges. So concerning the normative approach, and I'm here quoting Robert Beckman and Tara Davenport, who's here in the room, who identify different types of normative challenges: regulation of express EEZ freedoms in contravention of enclosed, deliberate or constructive ambiguity, or lack of definitions of key terms, lack of detailed regulations on certain obligations, and development not foreseen by enclosed. If we mention the challenges by themselves, not only on the legal regime, but also on the existence of the institution itself and on the implementation of the regime, we can mention climate change, dispute security issues, and so on. I'll say a few words about them. I won't be exhaustive. I don't pretend to be so, but I will just pinpoint some of these current issues. I'll start by delimitation, which is probably not the most important challenge nowadays, but it is a remaining issue. still raising some concerns in some parts of the world. Quite numerous bilateral delimitations have still to be delimited, often because of competing claims. Interstate disputes concerning these delimitations that have not found a diplomatic solution are fueling substantial arbitral and judicial litigation, including recent ones. It is not impossible that new disputes emerge from the competing claims of using the same energy in the EEZ. Challenge of sea level rise and permanence of the EEZ itself. Because sea level rise and its consequences are absent from the convention, a quite recent but absolutely crucial question is around permanence of EEZ and its limits, despite recession of baselines or recession of low watermarks. It is such a crucial issue for small island states. The question also exists around what would become of the EEZ in case of the worst scenario of when a territory would disappear or become uninhabitable. And we have to mention here that those small island states pushed for legal evolutions to the recognition of such permanence. An example is given by the Pacific Island Forum Declaration on Preserving Maritime Zones in the Face of Climate Change-related State Level Rise of August 2021. And more generally speaking, I would like here to underline the very important role of small island states in shaping the future of the law of the sea. Climate change, more generally speaking, is obviously a very striking challenge and threats on environment. We could mention at least two types of threats. A substantive threat to the sea's biological resources, which is overexploitation. Many fish stocks are in dangerous decline, despite an ever-growing body of law aimed at preventing resource depletion. Article 61.2 essentially states that it is the responsibility of the coastal state, taking into account the best scientific evidence available, to take appropriate conservation and management measures to ensure that the maintenance of the living resources in its EEZ is not jeopardized by overexploitation, and to grasp the content of the coastal state's obligations with regard to the conservation, preservation of biological resources. It is therefore necessary to move beyond the general framework of UNCLOS and to take into account numerous other sources of law. Also, the Convention has very important limits indeed regarding protection of environment, and that gives rise to fundamental questions for the future. The recent ICLS opinion on climate change is of crucial importance to understand states' obligation in this matter, and more generally reminds the fundamental task of the international judge, including through advisory opinions, to allow the EEZ regime to overcome the challenge of time. Today, the protection of the marine environment also raises complex legal issues in the EEZ. It reflects the tension between the coastal states. The first major legal question is the extent to which the general obligation laid down by the Convention and the relevant provision of international and regional legal instruments can impede that freedoms and rights of exploitation recognized to states over these waters. The question of how to reconcile obligations to protect the marine environment in the EEZ with the rights of states, it's likely to become even more sensitive, and we can already observe this in the regulation of marine protected areas. In the same vein, the tightening by certain coastal states of their regulations on maritime traffic in order to avoid pollution, accidents by ships, could hinder freedom of navigation in the EEZ. Also, very briefly, we can mention all the current questions around potential exploration and exploitation of seabed before 200 miles and the consequences it could have on the water column. In the context of the energy transition, which is essential to maintaining a stable and viable global climate, the exploitation of renewable marine energies is of obvious interest, as it would make it possible to cover a large proportion of the planet's energy needs, but raises very important issues regarding competing use or hypotheses where the coastal state may also authorize other states to have access to these sources. This hypothesis highlights one of the likely difficulties of exploiting marine energies in EEZ, competing sovereign rights to exploit the same energy source, such as the marine current, could arise between several adjacent or opposing coastal states. I'll also mention security. Security is a very wide challenge regarding the implementation of the regime and the regime itself. It is linked to the huge technical tools required to be able to ensure the implementation of the regime, for example, to fight against illegal fishing. We can also mention the specific case of cables. We know that the international network of submarine cables, and we talked about it this morning, is the object of a legal regime too elliptical that needs to evolve. There's a lot of stake here considering the world's increasing reliance on submarine cables for communications, the complexity of having very different actors implied, and the fact that a lot of states have adopted laws and regulation in relation to submarine cables which cannot be considered reasonable measures for the exploration and exploitation of resources. A lot of committees are thinking about this currently, including into the International Law Association. Finally, I would not like to conclude on a too dramatic note, but the challenge around EEZ legal regime has also to be replaced in the larger context of the growing tensions around oceans and the fact that the whole law of the sea, not to say in some aspects the whole international law, appears to be challenged. Thank you. Gamza Hamida.
Thank you, Professor Géraldine GIRAUDEAU. Thank you for that presentation.